we can have this conversation.
Yeah.
So yeah, so it was very interesting.
Yeah.
And it's the same guy that went and did the notice of intent to deny.
Okay. Okay. That's okay. I see. Yeah.
Because he said he looks like him. He described him.
Oh, the same office. Oh, well.
Gentlemen.
Ladies.
Yes, and ladies. Yeah. Absolutely, and ladies.
Children of all ages. It's
yes.
welcome to our circus. You know, Sam, I'm doing the introduction this time. Apparently, I'm Brian Burke. I'm an attorney with Shihab Burke here, based in Dublin, Ohio, and with me is my colleague and partner,
Sam Shihab.
Welcome, everybody. It's Monday. It's 6 p.m. It means Sam and I are here to talk about an immigration issue that we care about, want to talk about with you guys. So that's what we're going to do tonight, right?
Yes. So the topic we want to talk about today is common H-1B cap requests for evidence. And Brian and I were just talking here about why is this so important and how a request for evidence for H-1B application is different than a request for evidence for a regular H-1B.
Oh, you said your cap versus, the
cap, yeah. And the difference is for H-1B extensions, if you've been approved before, the H-1B review give you discretion based on prior approvals, and that's now is in the regulation. So if you have prior approvals, so they don't have to question your degrees, you don't have to question a lot of things, especially if the same employer, same job, same end client, they will just give you the benefit of the doubt. And the Biden administration, before they left, Brian, they
left a little gift on our doorstep.
Yeah, they gave us that.
Yeah.
The H-1B cap RFEs are different because you don't have that that opportunity to have had prior approvals.
Your case has never been tested before, you know. And usually, when one of our clients calls me up and says, you know, hey Brian, is so and so going to make an good H-1B case? The first question I'll ask them is, well, have they been on H-1B before? And the answer is, well, if they've been on H-1B before and you want to do essentially the same thing with them, there's always a good chance. Yeah. But if you're filing H-1B cap, you've never been tested. All the issues in H-1B case are novel to the government, novel for you, and it's H-1B cap season. The lottery starts on Friday, and no better time to talk about it, you know?
Absolutely.
Yeah.
But before we go into the topic, Brian, we are going to select questions from our new portal, which is immigrationquestions.us,
Sam.
.us. And why US, Brian?
It's US because that's what it says up there, immigrationquestions.us. If you want to go to the website, right, instead of putting anything else, you put .us after immigration questions, and that's why it's .us.
Because it's US immigration law.
Yeah, fair enough.
Yeah, so people are posting on questions on this portal. It belongs to us, belongs to the firm. And we are going to feature questions right at the very beginning of our YouTube and answer them. And today we have one that we've picked up from Sharat. Is it Sharat?
Sharat, yeah.
Sharat, yeah. Okay. She is asking an employment-based question. She said, my name is Sharath Sridhar. I have a 20-year plus experience in the IT network domain. And I have the following questions. My H-1B stamped in December 2000, and I was in the U.S. from December 31st, 2000 until April 27, 2001. So this is 25 years ago.
Yeah.
And I returned back to India. Am I eligible to transfer my H-1B instead of going through the lottery in this year? Question number one. Is it better to go through the transfer process or a new lottery in 25-26. So question number one, is he eligible to transfer the H-1B petition that he was granted 25 years ago?
And not only that, came to the United States for, you know,
a year and a half.
No, December 31st, 2008.
3 months.
Only a short amount of time. Now, the rules for H-1B are that you get 6 years in total, and they you can recapture the time you don't use, and meaning, in theory, somebody has 5 3/4 years left.
So the answer to question number one is, am I eligible to transfer? Is that a yes or no?
You can try it.
Is he eligible?
I believe so, yes.
He's eligible.
Yeah.
The answer is yes.
Yeah.
You don't believe so. The answer
I
is
know,
yes.
I know so. Okay, but Sam, explain why I'm all about this then. How about that?
Well, that's the second part
Yeah.
of it, because legally speaking, they're eligible. The law is very clear
Yeah.
on this question now.
Yeah.
It wasn't clear before. It's
January, I
clear
think the
now.
2017 regulations fix this, said, yeah.
Yes. So the question becomes, is what follows in the rules is that the burden of proof that you have not used up all 6 years is on the petitioner, okay? Meaning that on the company that's filing the H-1B, which falls back on the employee. And therefore, to be able to prove that you've only spent 3 months and not used up all your H-1B for the entire 25-year duration, you have to account for all the time and where you were in every time in the last 25 years based on your passport.
Yeah, I mean, my take is maybe a little bit simpler, a little bit more complex. It's, you know, if they see you're trying to recapture a 25-year-old H-1B approval, they'll go, and they will find an excuse to make it not work for you. Well, it's theoretically possible. So I guess maybe, Sam, I want to answer question number two. Question number two from Sharath is it better to go through the transfer process or new lottery process in the year 2025 to 2026? Here's the pitch for going through the lottery. One, well, at the very least, you get the full 6 years instead of 6 years minus 3 months. Second of all, if you get selected in the lottery, you reduce that risk of them finding some sort of complaint about your recapture from 25 years ago. And I think basically my take is put yourself in the lottery. If you go into the lottery and you get selected, forget about the recapture. If you don't get selected, that's when you make that pitch to an employer, and if they're willing to, take the risk, essentially, that's that. I mean, it should be recaptured, but man, 25 years is a long time.
You have to have all your passports for the last 25 years, which may not be a lot of passports. I mean, if they're
10 years a pop,
Yeah, so maybe 2 or 3 passports. That's number one. Number two, you have to account for every trip that you've made every day for 25 years where you've been. And that's a lot of work. And then they have to be convinced that they want to do that, because for them, from a policy standpoint, while the law is on your side, do they really want to open up every 25-year-old H-1B for recapture? And that's something that they've never told us they want, but we suspect that they may not want to do that.
Yeah, in like my vague recollections, I'm pretty sure I've gone like back 15 years before, but I mean, that's just a lot of time, Yeah.
But it's not impossible.
Yeah, the way the law reads, it's yes, and basically you might find sometimes, what's the always fascinating thing about immigration law is there's what's written down and there's what's not written down. You might find yourself butting up against a policy that nobody knows about, essentially, in a case like this. Yeah. But yeah.
We may pick up a couple questions from immigrationquestions.us next time.
Yeah.
As we said, we're going to answer those first at the very beginning of every session to get you guys more excited about leaving questions early. This way we have an opportunity to pick the good ones, the ones that are relevant, that can really provide the benefit to you as we go through this.
Yeah, it's fun. It's fun for us to get those in the middle of the week too. Just to give us something to talk about for sure.
Yeah. All right. So specialty occupation, H-1B RFEs.
The first most common is
wage challenge and all these things. So let's take it in the order. What's the first one, Brian?
Well, the first one
common H-1B cap RFE
is specialty occupation. Is your occupation a specialty occupation, right? And that's a classic H-1B RFE.
Was there a change in the law recently?
A little bit, yeah. So I'm going to go ahead and, for the benefit of everybody, put the language of the new regulations that went into effect in January 2025 up here. And the sort of highlight, one of the big highlights there is, is the section there about a position is not a specialty occupation if attainment of a general degree without further specialization is sufficient to qualify for the position. Basically, what that means in our mind is that, a general degree, if a general degree gets you into that occupation, it's not a good specialty occupation, which I'm going to sort of maybe echo what USCIS said in all the comments on these regulations, saying that's not really a change. That's sort of something that I always sort of, knew to be in my gut true. Now, the other sort of change worth noting is down here they have criteria. Position is not a specialty occupation unless it meets one of the following. So meet one of these and you're considered a specialty occupation.
And they give us 4 different options.
Yes, and it's the same four that have always been since I started doing my job, but they changed the wording a little bit. They say directly related.
Right.
Directly related, and that means a logical connection. It's right up, where is it here? I lost my mouse cursor. Well, I can't find my mouse cursor, but don't worry about it too much. Here it is. It means a logical connection between the required degree or its equivalent and the duties of the position. So again, if you asked me, at a cocktail party, and you were wanting a very boring conversation with me, and asked me that, I would say, probably might accidentally say directly related even before January 2020, because I used to say, I believe, just related is the bottom line. So the bottom line is, what does it mean is for specialty occupation? For the people who are what are the most typical H-1Bs, Sam, we see? Computer science, software developers, mechanical engineers, HR people, accountants, dentists, those are the sort of things where those are always going to be H-1B, good H-1B specialty occupations. It's maybe what this does is sort of, knocks out some that aren't so, where you just can't make a good argument for needing a degree.
So we can spend a lot of time talking about that.
Yeah.
My take on this is, I think the government took 2 steps forward, found themselves too aggressive, and then they took 2 steps backward, but they were too afraid to remove the word or concede it. So they said, oh, we're not changing how we do business, we're just clarifying. So they're saying what this really means is what we've been doing all along.
Yeah, I would, yeah.
Okay. But I note the item 3 and 4 talk about third party.
Mm-hmm. Yeah.
So this is where they are going to require, potentially, if the person is placed at a client site.
Yeah. What do they say about it?
That the client has to confirm.
Yeah.
Now,
so you segued, Sam. You're talking about. I think you're talking about the thing I want to talk about is how do you potentially avoid these things in your upcoming H-1B cap case?
Well, but before we do that, Brian, so it's all related. It's all related.
Yeah.
But that these contracts, these employment contracts, these contracts between vendor and client
consulting contracts,
and consulting company, they don't have language about bachelor's degree.
Correct. Yeah, typically not.
Typically are very wishy-washy on that.
Yeah, they're very differential. Basically, they say you're providing services to us. It's your response. Yeah.
So
I see what you're saying. So maybe it's per the regulations and the policy, or the regulations. USCIS says we care about the end client the most. We care about their opinion. But the contract the end client has with your employer, H-1B employer, is going to say, we don't know anything about this. You're just providing services to us as an independent contractor. We don't care about this. And that's the sort of language saying, if they ever start bringing up these things in RFEs, that's the sort of thing I'm going to be quoting to them. It's basically, guys, you're saying you want it from the end client. That's presuming I don't have an end client letter. I need to make an argument, of course. You're asking it for the end client, but the client it says, we don't know.
Well, some end client contracts they do know, and they do say we don't care about a bachelor's degree.
Yeah,
and that's a problem.
Yeah.
So sometimes they say we need people. We don't care. Bachelor's degree or 10 years of experience is okay. And then once they start doing that, then you may have an issue.
Well, yeah. So I'm going to put I definitely want to come around to this client contracts saying things, because let's talk about So having an end client letter that says something and having a client contract that doesn't say something problematic is useful. I'm going to maybe hit my general strategies on specialty occupation. And if they want to question, sometimes they question whether your job description is detailed enough. If you don't give them a very detailed, thorough job description, that can generate specialty occupation RFEs. So that's another way to approach it. Because if they can't figure out whether it really requires a degree or there's not enough detail for that, that's something that can generate these. That's kind of, in my mind, we've hit upon the 2 things, and most likely in H-1B cap scenario, is if you're in a consulting scenario, is the right person saying it requires a bachelor's degree? And the other kind of specialty occupation RFE is your employer didn't give us enough details about your job, about the work you're doing, so we're going to need a more expanded job description to figure out whether it's a specialty occupation.
It sounds like to me, Brian, that although I think we need to make a public announcement that We have not seen any changes yet, but keep in mind, we have not done any H-1B cap filing since the new rules. And the old regulation, the current regulations has this wonderful discretion language that they say, you know, we're going to give you the benefit of the doubt. Now, for new H-1Bs, are they going to request for every time we place somebody at a third-party site, they're going to require an incline letter confirming the degree?
I mean, I've had this conversation with our clients, and basically, my honest answer is just what you said. Is, you know, we haven't seen a radical shift in policy yet, but it's written in the rules that we can request, you know, contracts to confirm, you know, the bona fides of your work, as well as that you're going to be employed in a specialty occupation, right? And you know, I told them, well, I haven't seen this change yet, but here's my prediction. I'm going to sooner or later be seeing RFEs, right, on the subject, and they're going to be saying, it's in our authority to request contracts, you know, work orders and similar items, you know, to confirm the bona fides or specialty occupation, things like that.
And the third-party site is one of 4 different ways you can show specialty occupation. So they have the word, the qualification or. Well,
even outside the specialty occupation context, though, because you still have to show bona fide work, they're still going to, in client letters, they're still going to be relevant to that as well.
Right. So all right. So that's enough about specialty occupation. I think no change. But I think the language, I think we should let everybody know, the language that they have now is, number one, amenable to insisting on an in-client letter confirming the degree. Number 2, it's tighter a little bit. So for the traditional jobs, I don't think there's a problem. What's a traditional job? Mechanical engineer, software developer, you know, nurse instructor, where the law requires the law requires a bachelor's degree. There's no question on these. I think they're set. Electrical engineer, etc.
I think the classic ones where, you know, you go to school to get a degree for that job, like lawyers. You know,
CPA, you know, certified public accountant. You know, but when you get into jobs like project manager, computer programmer, systems analyst. And then the weaker ones here that we have on our list that we're sharing with everybody is like web developer. And you don't need a degree for that one.
So, I mean, the whole point, I guess the point of this list is, you know, those are all SOC job codes, right? The job codes that your employer selects for your LCA. And there are certain job codes that are just more likely to get those specialty occupation queries as well. So I guess we have a third pillar for our list. It's, you know, if you don't have good information from your end client, your consulting scenario, that can get you a specialty occupation RFE. You give a weak job description, they will get one of those ones that says, we need more job description if we're going to figure out if this is a specialty occupation. And if you pick the wrong job code, they can basically, that can torpedo your case right there. It's we don't think this is a specialty occupation in general.
Right. And I mean, obviously, the government does things, I mean, they have the benefit of looking at this case backwards sometime. So they may just simply flip to the page where the salary, the offered wage is, and from there work their way backward into the case and build their critique that way. So if your salary is low or marginal, if it's a level 1 occupation, you know you may have a challenge that may not be related to, you know, you could be a mechanical engineer, but they may say no. You're a mechanical drafter.
Conveniently, we have a slide about LCA wage levels here, which is sort of relevant. So you're sort of right on the cusp of, like, wages can impact whether somebody's willing to believe it's a specialty occupation, because if you're getting paid that amount of money, that job doesn't require a degree. But one of the things that's potentially come up is whether your LCA is right, and this is where LCA wage levels come in. Something we haven't talked about as much regarding the new rules, but they explicitly state in there that they have the right to make sure that your LCA aligns with your offered position, right? And, you know, for the benefit of anybody who's never seen them, right on the screen right now are your LCA wage levels, description of them, level 1 through 4. And here's what bothers me. So when you read these descriptions, Sam, they describe a person and the nature of their work. Right? There is, you know, level 1 is entry level, level 2 is sort of, you know, qualified contributor, and level 3 and 4 are the more sort of senior roles. And it's possible to get an RFE if they think, you know, that your work doesn't align with the wage level that you've been assigned. Now, I think the most interesting part of this slide, Sam, is the part on the very bottom. Basically, wage levels are generally based upon educational experience requirements, as well as any leadership or supervisory duties. So basically, even though they describe the wage levels in terms of what you're doing, they also have a way of calculating what your wages should be through a complex system called SVP, which I'm not going to bring up. But the bottom line is, if they look at if there's a stated requirement for your position, and it's higher than what they believe is appropriate for the wage level you're at, that can cause problems as well. So you mentioned, contracts earlier, contracts commenting and saying, here's what we expect out of our software developer you're providing to us. And if it says, bachelor's degree and 10 years of experience, and even though you guys believe it's an entry-level position, the government's going to, and you give them an LCA that says level 1 or level 2, that's kind of it. I think these wage levels are are just absolutely disassociated from the way business works, essentially.
Well, so there's a lot that goes into the wage, but the bottom line is this: the wage level can hurt you, but it may not help you. So level 1, it definitely brings a lot of doubt. Yeah. And level 4 that has other problems may have its own problems regardless. So, but if you have a low level, level 1 or 2, and most H-1B cap, they're going to end up level 1 and 2.
Well,
and the one of the issues that we've dealt with long time ago, which I think is getting better, but we haven't gotten rid of it 100%, is the question of, if you're working remotely from home, how can you be level 1?
Yeah.
So this was something that they hit on hard at the beginning. There's no he's not supervised.
Well, how can you be working off-site either? If you're doing a consulting job, can you be off-site and working at a client site when your employer's, if your employer's in Dublin, Ohio, and you're in Des Moines, Iowa, can you be a level 1 either? If level 1 is supposed to require...
The counter to that is... I have a team of 7 people and a supervisor on site.
Well, you just change the facts of me. So good point. Yeah. Correct, so you're right. So
but he's working from home or he's working alone at the client site and he's level 1. Yeah. You're going to say, how is that?
Yeah.
How is that possible? Yeah. So all these things plays into triggering requests for evidence. And when USCIS triggers, so let's assume there is one item that they're bothering them. Maybe it's your degree, or maybe it's your wage, or maybe it's the title of the job, or the end client, for whatever reason they don't like the placement. They're going to hit you with an RFE with 25 different things.
Yeah.
Why? Because they use templates.
I was just going through, I didn't know you were getting to it, but I wanted to bring it up, and I'm glad I heard you out, because,
They use templates, and when they use templates, they're not going to draft a special one for you. Yeah. They're going to say, this looks like a template number 3. Yeah. And they pull template number 3, and they put your name, the company name, and it just populates. And then they read it and modify it a little bit and add a little bit to it, and then it goes. Now you have an RFE with 15 different things, of which 14 we've answered completely on the original H-1B petition.
Anecdotally, I'm working on an EB-1A case when you just got an RFE, and they send in that case that's filed by my client directly, so they're going to send a copy to him, and I'm just worried about him reading it. He said, Brian, the very first thing when I talked to him about it, I said, well, just to let you know, it's pretty clear to me they didn't read this, and a lot of this RFE doesn't apply to you. It says you're a researcher, you're not a researcher, things like that. He's like, Brian, I figured that out too, because I Googled some of the language in it, and I found a USCIS template for the RFE online. They just go through and delete sections that they don't think apply, and they barely do any work on them at all. Yeah.
So speaking of that, you brought up EB-1. We're still doing 5 to 10 courtesy EB-1 evaluation a year. Once we hit a certain number, we stop doing that, because obviously we can't sit all day. So if you are interested to do an EB-1, send us an email. If you're in that group that we're still doing it, we may get you an evaluation at no cost. But degree and relationship to the H-1B position is the next exciting potential RFE question for CAP cases.
Yeah, so closely related, I put our slide up here too. So degree relationship, essentially, it's kind of closely related to the concept of specialty occupation. So if you're in an occupation that normally requires a degree in computer science or something like that, do you have that? And this is something that when these new regulations came out, when they first proposed them, and maybe I didn't hear as much talk when they issued the final ones, people were scared, basically thinking, I have a degree in an unrelated field, in a somewhat unrelated field, a marginal field, how about that? Am I still going to be able to get on H-1B status? And for them, there's still deference available to them. But the question is, well, if they don't consider, I don't know, mechanical engineering to be directly related to IT, am I going to be able to get an H-1B? And I guess the answer to that is the old classic 3-to-1 rule. They can take 3 years of experience, well documented, and combine that with your education, turn your degree into something else. So that's out there. Really common H-1B
vehicle tool that we use a lot for people and that have a lot of years of experience. Now, remember, it's not a resume type of detail. You have to get a letter, document it, etc., which typically we haven't seen problem. Most people are able to do it.
So I guess this is an RFE issue. Most people are able to get the letters. We overcome them. But the best part about this one is this is something you can spot early on. It's a sort of thing where it's hard to control specialty occupation RFEs. You can try to, but sometimes you have to deal with the facts. The facts of that's the job description. That's what it's doing. The employer knows it's marginal. You're going to go ahead with it. Something like that. Yeah. For degree relationship, you can tell. You can tell usually when they're going to question them, and you can prepare for it by getting good. When we're doing a cap case, we'll let our employer clients know, saying, "Hey, so and so has a degree that's going to be marginal. Get them started on getting those letters now, such that you don't have to rush during the 87 days of your RFE."
Which they can give you a lesser time if they want. So degrees such as an MBA alone is not a specialty occupation. A degree such as political science is not a specialty occupation. A degree such as, what's another degree? History. Journalism probably.
But combine that with the right amount of experience. A good evaluator might be, typically, again, 3 years is the minimum to get any sort of movement on what your degree equivalency is. And typically with something like, business administration degree, you got 3 years of experience, they can move that to management information systems, for example. And there's that.
But to give people guidance, I think a lot of people who listen to these sessions, if your degree is in the technical field, medical, scientific, mathematics, engineering, you can probably, with a little bit of work, make it work.
Yeah.
If your degree is more in the arts and more into an abstract areas, then it may not be as helpful. We move on to the next topic of RFEs for H-1B cap cases, Brian. And the next one is a big one. Dealing with maintenance of status.
It's sort of universal to everybody. Anybody can, as long as you're applying for a change of status in the United States, you can get hit with maintenance of status. And again, this is built into the regulations. It just sort of baffles me, but they codified as part of the recent regulations that yes, you're required to initially give us evidence of your maintenance of status. It wasn't required before, and basically, I guess that means they can issue a NOID or deny your case if you don't give them evidence of maintenance. Fine. What does that mean for the average person? If you're on F1, well, let's talk about, we have some good notes here. If you're on something like H4, L1, L2, BN, and TN, basically one of the problems that people have is their status. If you're going to get a change of status in the United States, your current status must extend all the way through 10/1, October 1st.
Yeah.
Meaning, if your H4 is expiring on June 30th, and well, that's before October 1st, you're going to get an RFE on that. And there's ways to remedy that. For example, you file an H4 extension to cover that time. But that's the common issue there.
As we're running into the mid-hour,
I know,
we can probably quickly say your OPT, CPT time, there is a lot of rules there about maintenance of status, being unpaid internship problematic, gaps in your employment when you're on OPT, more than 90 days, and then more than 60 days if you're on the STEM OPT extension, and if any gaps in employment in the CPT, curricular practical training.
They really don't like CPT. They love issuing RFEs on that. Every time they hear about CPT, they're looking for some sort of non-compliance on it. Some schools have sort of pre-prepared responses for that for people, but those F1 maintenance of status ones are usually really the most complex maintenance of status RFEs you're going to get. And part of it is because like you said, there's so many complex rules relating to student visas, and this is my heart fluttering for the people on student visas. They don't really get good advice a lot about their status. The
best way to describe it, Brian, is I feel that when the government discovers a deficiency in their maintenance of status, they move quickly to a checkmate.
Yeah.
You have very little room to maneuver around it because you have more than 90 days of unemployment.
Yeah.
You have
A lot of those, yeah.
Yeah, you have. So it's basically they just make one move, checkmate. You have violated your status, and therefore we cannot change your status. Now you could get this H-1B approved, and this person has to leave the country, get stamped, and come back. But it means that the change of status from an F1 to an H-1B is not going to happen. So maintenance of status, any concerns with maintenance status, talk to your attorney right away at the outset, trying to get it resolved. With that, Brian, let's take one or two questions.
Yeah, let's get it going.
Yeah.
So I guess we have to sort of make our disclaimer here about when we're answering these questions.
And if we can use that bigger screen, that would be great.
Oh, we can definitely do that.
Yeah.
So we're going to take some questions here that have been sort of put in over the last half hour. Obviously, we're only getting a little bit of a snippet of information from you. There's so many nuances about the questions you guys ask. I would just remind everybody, no attorney-client relationship established. And if you hear something here you like, think it's interesting, or want to know more about, talk to an immigration attorney of your choosing. Talk to somebody who does employment-based, because not everybody does. Ask them that, because there's a lot of people who are just focusing on deportation, asylum, that sort of thing. But talk to somebody about employment and immigration, because, well, they'll give you some advice, that's for sure. And
if you remember a question during the week, just remember to go to immigrationquestions.us. That's our portal. And drop your question there. Two things will happen. Number one, you will have the opportunity to have somebody look at it before the session, so you'll have a better answer, and it will be answered at the beginning of our YouTube. So in the first 5 minutes of the presentation, these will be answered. The selected one will be answered, because that gives us an opportunity to select some good questions. Also do a little bit of looking into a question instead of just shooting right away and seeing it for the first time. Without further delay, let's go to our first question.
Yes. From Sneha Mehta.
Hi Sam, Brian, under new administration, does a green card holder needs to carry a physical green card all the time in their possession, or a copy of a green card picture is enough? Thanks for answering. Do you have to carry a green card with you all the time?
I believe
I don't think you do.
I believe I could have sworn it says you're supposed to copy evidence.
I think if you have a copy of your green card with you, but you don't want to carry it around, because losing it and replacing it is a nightmare.
I would agree with that. Yeah.
I mean, I'm comfortable with that, having a copy, because they'll check on it and it's at home. But I'm not sure you have to carry it with you all the time.
For some reason, there's some sort of residue in my head that says. But I mean, I agree with you, Sam. Losing your green card is miserable. It can take like a year to get a new one, and it just ruins your life on that one. But Sneha has a related question, which as you do that bit of Google, I'm going to answer it. Is there any disadvantage if we apply for citizenship before we complete 5 years of being a green card holder? Please provide guidance. No disadvantage. You're allowed to. For those who aren't familiar with the question, when you apply for U.S. citizenship, you can actually apply 90 days before you reach 5 years of being a permanent resident. The logic being, as I understand it, is that you're eligible under law to become a citizen when you hit 5 years of permanent residence. But if they only allow you to file when you hit 5 years of permanent residence, well, effectively, it takes some time to process a citizenship case, meaning effectively the time is longer, and that's why they allow you to file earlier, I guess, is the short answer there.
So I kind of looked at it. It looks like there's a regulation that requires you to carry the green card with you all the time.
That's my recollection. It's just, I have to recommend compliance with the regulations, especially, I mean, Sam, we should be talking about that registry thing as well here sooner or later. But
I think what the discussion is evidence of so evidence doesn't mean you have to carry the card. So a copy of it, and I'm comfortable. But if you have a copy, like if you make a copy of it and cut it and laminate it, and write on the side copy, so they're not thinking that you're
trying to give them the fraudulent
copies. Just say my copy on the side in red. and stick it in your wallet, I think, and keep the green card at home, I think I'm okay with that.
Yeah.
I will defend that any day.
Yeah, I think it's reasonable because again, it's really easy to lose documents like that.
Don't carry the damn green card with you all over the place because it's about. I mean, how many times have you lost credit cards and driver's license? And it's a nightmare trying to replace a green card. All right, especially with the enforcement and the employment and the I-9 and all that crazy stuff, it's not worth it. All right, sounds good.
Let's check out Tech's question here.
All right, sounds good. So Tech, my H-1B was approved in 2023 for 3 years. I went to India and came back on advanced parole. I am continuing to work with the same employer without using EAD. I'm planning to file an H-1B extension next year. My question is, do I still need to update I-9? Can we file H-1B extension along with the amendment before 8 months? So let's go back to the first part of the question, because the first part of the question assumes something. So he says, I joined on an advanced parole, and I'm working without EAD. I'm not using my EAD. So he assumed that he is now using his H-1B. Now, is he using his H-1B or is he on EAD right now?
He is using his, well, per a 25-ish year old policy memorandum, if you leave, if you have a valid H-1B approval, if you're on valid H-1B status, right, with employer A, you leave the United States, come back and rejoin employer A, we will honor your H-1B work authorization through its approved duration.
And that's the danger of quoting something that you haven't read in a long time.
Yeah.
I make the mistake, the same thing. I'm not sure it says that.
Yeah.
Well, I think it says if you come back and you do not have a valid employment authorization document, you're allowed to do that. And that's where the confusion is, because it was designed to say you can continue working without an EAD. And we're going to assume you're on H-1B.
Yeah.
So I doubt that he is on H-1B, although if he extends, I think they'll honor that.
Well, yes. If he files to extend his H-1B,
they'll honor that.
They will put him back in H-1B status, for sure.
Yeah. So, but I'll be interested to maybe we'll look at it later, because my reading of it could be also wrong because I don't have it in front of me.
Yeah.
But my recollection is it wasn't really designed to address the question. You have an EAD with you, but no, you can choose to be on H-1B. I don't think so.
Yeah?
Yeah.
Well,
but I could be wrong because we could read it and you can say, "Oh, Brian, you're right."
Here's what I will say. I'm not worried about Tech generally because, well, either either you're on H-1B or either you're not on H-1B. Either they're on your H-1B work authorization, or you have the EAD, which is covering you.
Yeah.
Fine. And so then comes the question of, do we still need to update Form I-9? Now, Form I-9, I'm going to quote us of last week. Form I-9 is your employer's obligation, is the bottom line there. That's that.
You're 100% right, and you've answered Tech a very important question. Does he have to? He doesn't have to do anything, obviously, unless and until the employer asks him to.
Sure. Yeah, if they need, it's time to re-verify as I-9,
Yeah. So I think the employer should update the I-9 as he had a new entry into the U.S.
Yeah. That's a scenario which you have a different, if they screw up your I-94, you have a different stay, for example. Yeah.
So the answer is the employer should update the I-9. Yes.
Yes, they definitely should because So can we file H-1B extension along with amendment before 8 months? So 8 months, I'm not sure as to the significance of that, but here's what I would say. You can file an amendment at any time if there's good reason to. And an amendment with extension would put you back in H-1B status.
But why is he doing an amendment unless the conditions have changed? So when do you file an H-1B amendment, Brian? Let's advise people.
Well, when there's been a material change in the terms and conditions of your employment, and there's only one thing they've ever said for sure is a material change, that's a change in work site to a different metropolitan statistical area, which would require a new LCA.
Right. I mean, there's other things, but that's the big one.
That's the big one. That's.
Yeah. So did he change his location?
I don't know, but again, hey, you're adding facts to the soup, Sam. I'm saying,
but why is he asking for amendment? And why is it 8 months?
Yeah, maybe we meant to say 6 months, because 6 months is typically the time frame out. You can do a extension. Typically, they don't want to get an H-1B extension request more than 6 months out. Maybe that's what.
Maybe Tech can throw in a clarification. We'll be happy to come back to it. Yeah.
So, hey, here's a cool one from a frequent flyer here, which is a very appropriate terminology to use for a guy whose name's Sky Limit, or gal.
That's right.
Sam and Brian, I just wanted to tell you I received my green card EB-5 through WOM. Priority date was December 2021. Thank you for such an informative channel. You guys have made this painful journey easier for me.
Wow, congratulations for your EB-5 approval.
Yeah.
That's wonderful. That's a great accomplishment, and good luck for being a U.S. permanent resident. And maybe not too long from now, you'll apply for citizenship and you'll close the chapter on this immigration journey that has taken you many, many years.
Yeah, I don't like it as an immigration attorney that he describes the process as painful, you know?
It is
but
painful.
I mean, it's a conversation I have with people. So what is WOM? Can you figure that one out?
Oops. I do not know what the WOM
is. Yeah, maybe Sky Limit will inform us what that. Maybe it refers to a regional center or something, perhaps. Here we are, more from Sneha Mehta. Hi, Brian. That's me. This one's from me, Sam. Go away.
Go for it.
Hearing news on YouTube that green card holders who got green card less than 2 years are getting deported at POE. Do your team come across such cases? I have not come across a case of a green.
Hearing news that green card holders who got less than 2 years, who got green card less than 2 years are getting.
That's 2 years ago, yeah.
No, there's no such thing.
Well, you can be denied. Okay, it's possible. Okay, I'm gonna
change the facts.
Yeah, I'm gonna add some facts here. It is possible for somebody to arrive at a port of entry with a green card and not be admitted to the country. For example, I don't know. Maybe some sort of criminal matter has come up and you're rendered inadmissible. They were going to put you. That's not at the port of entry though. Deport it? I don't know. I think no. I've not heard of that.
Or maybe those who have been out of the U.S. for more than 1 year. They're not allowed to come into the United States unless they go through the CR1 process, right?
Yeah. Public service announcement. If you have a green card and like Sam said, if you stay out of the country for more than 1 year, your green card is likely to be questioned at the border, and that's that. Yeah.
So let's deal with the preservation of the green card, whether you've abandoned your green card. But there is no news or common practice that we've heard whatsoever about this. So this is maybe an isolated situation in which there's a lot more facts to the scenario that we do not have today that probably would be relevant.
Yeah.
All right, sounds good. So
see what we got here. It's sort of a bit of a follow-up from Sky Limit. So this is Sky Limit, who's recently got a green card. If I decide to travel outside the U.S. and come back in 10 days, besides the green card and passport, do I need to carry any other documents? Is it safe to travel on green card for 10 days?
Yes, it is safe, no question. As a green card holder, and maybe we can talk about, since he's a green card holder, what are the rules about preservation of the green card?
Yeah. If you leave the United States for more than 6 months, they will question whether or not you've.
There's a presumption that you may have abandoned it, and the presumption is on that you can rebut that.
Yeah.
But if you are outside the United States for less than 6 months, there is not a presumption of abandonment, and therefore a short trip of 10 days, 20 days, 2 months. And then coming back, especially if you have your life in your car, your job, your whatever, family, friends, apartment,
lots of things showing that you still live in the United States.
Yeah, there's no issues whatsoever as far as travel.
Yeah. I guess, Sam, I always want to say, people. I have a surprising number of consultations. People who say, "Oh, Brian, but what if I just can I keep this green card if I just come back every for 2 weeks every 6 months?" And my answer to that one is the customs folks will eventually call you out on something like that if they figure it out anyway. Essentially, permanent residence it's where you live. You know, it's where do you live, and if it looks to them like you're not really living in the United States anymore, they can actually question your permanent residence on that.
I had an interesting consultation along the same line. This lady who seemed to be definitely a highly technical person, because the type of questions, give me a list of all the forms, give me the dates, give me the filing fees, give me so many details, and I was happy to share the information. And then at the end of the conversation, she was trying to apply for her mom. Mm-hmm. Then the conversation, she said, maybe this is a silly question, Sam, but what's the benefit of me applying for my mom for a green card? And I said, you've asked the most important question. Of all those questions you've asked me, you just now have asked me the most important one. And I basically told her, listen, if your mom does not want to call USA her home, and she's just using it to travel here and see grandchildren, that's not a good...
I had that kind of consultation recently. It's like, I'm still working in my home country,
Yeah.
And the answer is, I know what you want. You want to be able to come and go and just see your family whenever you want. And visitor visa, you can't spend more than 6 months at a time. But if you have a permanent resident, you got to spend more than six months. There's no perfect option for that.
She was so appreciative. She said, now I get it. And I said, you need to ask your mom, where is home?
Yeah.
Because if you think home is still back home, whatever country you're from, and you're just coming to visit, this green card is not for you. Because I told her, you're going to spend a lot of money and time getting that green card, and then you're going to spend a lot more effort trying to protect it, and you will be your mom will be harassed.
Yeah.
When she's gone for a long time, she said, you just help me out. I said, maybe 5 years from now when things change and she's a little bit older. I said, how old is your mom? She said 64.
Yeah.
And I said, she's young. She doesn't want to be here. Wow. She wants to be other places, I mean,
I've had families where it's, my parents were permanent residents, like 15 years ago, and they decided, they don't want to be here. It turns out they didn't really want to be permanent residents, and then it's 15 years later, do another I-130 for them, and they'll come, and that's what happens,
Yeah. So it's very important to understand the purpose behind it. Yeah. But your travel for 10 days is absolutely not a problem.
Yeah. So a couple repeats there. Let's check this one from Sonu.
All right, so EB3 approval on February 1st, 2013. Okay, adjustment status application filing was based on EB3 I-140 in 2024. Okay, EB2 was approved for a different role but was not linked to the pending I-45 application. Now priority is current. What is the next step? So, great question. So this person has I-140, I-45 pending in EB3, and now he has a new labor certification, looks like a new I-140.
I don't interpret it that way.
EB2 was approved for a different role, but was not linked to pending I-45.
Yeah, I see.
Okay.
I see.
So,
different role. I missed the in 2024 part of that.
Well, that's why I want to kind of rephrase it my way.
Could you tell? Could you tell I couldn't tell?
No. I don't assume. I'm just. So I-140 approved for EB2 now. Priority is current, I'm assuming, for the EB3.
EB3 dates are ahead of EB2, yeah.
Yeah, because they're ahead.
Yeah.
The question becomes, what should he do? Because it looks like maybe the...
well, here's a little bit more from Sony. Maybe
it's a different job now. He does not. He does not want to take a demotion.
Well, yeah, it's a demotion being the EB3 case. So basically, we're presuming, and I agree with you, that the EB2 one is basically, the reason why you did a new labor certification, I'm presuming this person's still with the same employer, is that,
he became a director or something like that.
I've done that scenario before, a new job, new requirements, you want to be in that role.
Right.
So we're gonna see what they say.
What he says here. I'm primary applicant, my priority is current I-45 application NBC. But my spouse is at Orlando Field Service Center. Does it make a difference? So that's a little bit a different supplement question.
Yeah.
So back to the previous question. What would you do, Brian? So you got an old job in EB3 that's ready to go forward, but you've moved on to a new job and you have a new I-140 in EB2 that's going to hold you back a little bit.
Well,
what would you do?
Well, it depends. It always depends.
Every lawyer says that. It doesn't help
it
doesn't help my client.
Hey, it depends.
Yeah.
It depends. You tell your client this. It depends about the the currentness of the priority date. So what I want to say is it's simple. If you're current in the for EB2 as well, right? You want to do a transfer on underlying basis, move you to the EB2 category. You get a green card in EB2, right?
But you're gonna hold back a little bit.
Well, it's
a few months back. Well, EB2 is not
I don't know. We don't know.
Well, you can even do a transfer underlying basis.
Actually, you know, Sam, we're sitting here talking about what the priority date is. We have the priority date right here, EB3 approval. Oh, it says EB3 approval 2/1/2013. I imagine that's what the priority date is. So I'm gonna go to the visa bulletin.
Sure.
Answer that question fully. So March 2025, visa bulletin. Final action dates is final action dates for employment-based.
Let's assume Sharma is born in India.
Mm-hmm. Yeah.
And looks like December 2012 and in 2013. So 2000.
Well, they're not. If 2/1/2013 is the priority date, they're not current in either category right now because the requirement is before the posted date on the visa bulletin. So there's that. But you're right. This is going to be a problem where they're not going to be current in. They're not going to be current in
EB2.
Yeah, in EB2.
Whereas they are current very soon in EB3.
EB3.
And the distinction is not that big, Brian. So December 2012 and February 2013 is not that big of a gap.
Yeah, it's a couple months. Yeah,
it's a couple months, and you don't want to file an application with the wrong job.
Yeah. Well, you don't want to.
Now, the only argument I would make, possibly, is whether or not I can argue that the EB2 job that he has now, I don't have the job description, is a natural extension of that EB3 job that he did, such that
same or similar occupation.
Well, I won't. I mean, it's the same or similar occupation argument within the same employer, if you will, such that you can, in good faith, continue with the EB3.
Yeah, so that's where I'm because you would agree you cannot do a transfer on an underlying basis yet because the EB2 priority is not current, right? So you can't do that. So, but you want to get your green card based upon the job that's the loftier one. So what you could do is you could file an I-45J right now that says for the exact same job. You have to be careful with the way you file this 45J because in the beginning of it has two boxes. One is to basically there's a same or similar occupation or confirm the job on a 9140. And what you could do is basically, presuming the EB2 job is the same or similar occupation, you could say, here's the supplement J that's moving me to a same or similar occupation that's identical to the one that's on the EB2 I-140, but not moving, but not the same one. It's not the exact same job because there's a labor certification for that one. And that would keep me in the EB2 category, sorry, EB3 category, but would move you to the exact same role. And that's sort of that. But what was the point?
But we have to look at the job description.
Yeah, because that makes the question say, well, why would anybody have you do this labor certification then? And we're presuming the same employer.
Because everybody assumed EB2 is faster. It makes a lot of sense.
Yeah.
And he's moved up.
Yeah.
To EB2, so why not take advantage?
Yeah, but if it was the same or similar
managerial position, now we're assuming the same employer. Yeah. And if it's not the same employer,
well, this all gets opened up.
That's even a better argument. Same or similar occupation becomes even stronger.
Yeah.
Because
so you're pointing out basically that employer having a same or similar occupation, like what stresses me out about what companies that I worry about is, especially for somebody from India, you file your green card 10 years ago, and then somebody goes, oh, it's time, your priority date's current, and you go, oh, who cares? We're just going to we're going to file, and you can't do that. If you ask me, I'm an immigration attorney. You can't file based upon a job that they're qualified for. You wanted to be 10 years ago if what you wanted to be is something far loftier, and that's maybe why they're doing it. Yeah.
So it all begins, to summarize here, because I think we've talked about a lot of things. It all begins of what is the EB2 job description, what is the EB3 job description, and are they a progression one, progression to the other enough that we can argue that same or similar job occupation and move you on that EB3 application forward.
To that role.
So that's the possibility. Or wait 3 months and go with the EB2.
Wait 3 months of visa bulletin.
Then do a transfer underlying basis and then good luck.
Yeah.
3 months for visa bulletin is 6 months.
Yeah.
Minimum.
Yeah.
And then that's a half a lot, and then who knows, things can retrogress.
Yeah.
crazy stuff happens.
So let's answer Sonu's sort of additional questions here. I'm the primary applicant, 45 applications at NBC, but spouses at Orlando Field Service Center. Doesn't make a difference. Will USCIS contact us? Don't think too much about these things, I guess. I believe you if you've looked into it and they've told you that, I'm at the NBC and my spouse is not, but
they will not. No, you need to contact them. You need to be proactive in telling them, here the application, please pick up this application. You need to be proactive. Yeah. You just cannot rely on the government figuring out that.
Well, I will agree that it'll take them some time to figure it out themselves, and I'll give
and that wastes a lot of time.
Yeah. So from Rod's channel here, my I-45 case moved from NBC to a non-local field office. Why are cases moved to a non-local field office? Is it unnecessary to think the decision will be made soon? Thanks so much.
Well, first of all, I have to assume that you're current, because if you're not current, the decision will not be made soon. Right?
Well, they might interview you. They've been known to interview people who are not current.
Well, even a non-local office.
Yeah, non-local office. You're right. Yeah. Yes.
So I'm assuming you're current.
Yep.
And yes, moving things to a non-local office is trying to distribute workload to move cases along, normally. Now, that's a very general answer to a very general question.
Yeah.
But that would be my best answer to this one, Brian.
That's a fair one, which I would agree with, yeah. Let me see here. Sir, I heard that if we apply for citizenship after 5 years of completion, they can't cancel a green card, but if it's applied 90 days before 5-year completion, USCIS can easily cancel. I'm kind of confused. Well, somebody is going into basically deep into rules about rescission of green cards, essentially like the ability to claw it back within 5 years, right?
The answer is but the answer doesn't make any sense, because nobody's going to talk to you for at least 6 months.
Yeah.
So by the time they talk to you, you have crossed the 5 years, for whatever that's worth. And also, just keep in mind, the cancellation of green card is not a common thing that happens every day. These are in 30 years of practice, I may have encountered few of those, but not many at all.
Yeah, I mean, once every couple of years we hear something like
but not very common at all.
I guess here's what I'll tell you, Sneha. If your green card was gotten in good faith in an honest case, that's something which is theoretically possible, but that's like winning the reverse lottery. Don't worry too much about it.
Number two, if the 90 days is bothering you too much, just wait.
Yeah.
And do it after 5 years, if that makes you feel comfortable.
Yeah.
It doesn't have to be all the time logical. It doesn't make any difference. You want to wait 5 years, you get your 5 years and then apply? Do it. 5 years and 10 days, and then apply. No big deal.
So, some questions coming up here. Is it mandatory to file I-45J if I am changing to a new employer for same role? I have a green card EAD with 485. So the answer is, they don't really impose rules upon you when you're supposed to file an I-45J. They say you can give it to us in an interview, you can give it to us as an RFE, or whenever you want. And I don't think they've changed that policy at any time. But for my peace of mind, I'd be submitting that supplement J when you're sure you want to be with this employer on a permanent basis.
Yes, if you think that you're going to be with this employer for a short period of time, it's not worth it.
Yeah.
But if you feel...
I'm sorry.
Yeah, if you feel that the assignment is permanent and there's some red tape in the company, it's going to take a while, get that thing out of the way. It might be a good idea.
Yes.
It doesn't cost anything.
Yeah, if your green card's been pending for a couple years now, which I'm going to imagine it was probably something 2020, 2021, if when your party date comes up, they're going to probably issue you an RFE for a supplement, ask you what's going on, do you still have a job available, and you might be able to head off an RFE if you actually, do that.
With that, we are going to end today at 7 o'clock, but if you get your questions to immigrationquestions.us, and Brian is trying to show that on the screen, you will get your questions answered up front at the beginning of the YouTube channel. That's if we selected them. These have to be good questions, and that gives us time to kind of read them and bring them in here and start with them right away, and that can be very helpful to get things rolling. So immigrationquestions.us allow us to get those questions before the session begins, and if you throw them in there and they're good questions, we will answer them at the outset, at the beginning.